It gives me great pleasure to introduce our speakers and moderator for this closing panel session. The subject matter, of course, the rise of mediation, bridging differences for tomorrow. Our moderator is Professor Lucy Reid, Director, Center for International Law, National University of Singapore. Professor Reid teaches conciliation and mediation of state-level disputes at the NUS Law Faculty. She is an esteemed thought leader in the international law world. She is a vice president of the Singapore International Arbitration Center and a president-elect of the International Council for Commercial Arbitration. She previously worked in the U.S. State Department Office of Legal Advisor and was also formerly president of the American Society, there she is, of International Law. There we are. Ladies and gentlemen, a round of applause for Professor Reid. She's up here right now with us. Moving on to the panelists. We have Ambassador Iftikhar Ahmed Chowdhury, former Foreign Advisor, Foreign Minister, Bangladesh, and Principal Research Fellow, Institute of South Asian Studies. He's right here. Let's welcome him with a round of applause as well. Dr. Eme Muyoboke Karimunda, President of the Court of Appeal, Republic of Rwanda. There he is. And finally, Professor Thomas J. Stepanovic, William H. Webster Chair in Dispute Resolution and Professor of Law, Pepperdine University. Right, Professor Reid, I'm going to hand the floor over to you, ma'am. And ladies and gentlemen, enjoy this final panel discussion.
Thank you. For those of you who are still with us, you will not be disappointed. This promises to be a very interesting panel. You've heard panel 1, which is on multilateralism and the rule of law in an evolving world, and panel 2 on the future challenges for access to justice. And this panel 3 brings you to the rise of mediation, bridging differences for tomorrow. The focus of all of these panels, as set up so well by the Ministry of Law, is on evolution and the future and tomorrow, because it makes perfect sense when we're talking about the Singapore Convention, because the Singapore Convention is new. I would say it's born now, but it will be really born 6 months after the early ratifications. But while we're waiting for that birth, there is a great deal of anticipation and planning that needs to be done, and some crystal balling that needs to be done. And our panel has this broad title of looking at mediation in the future with a tether to the Singapore Convention. And our panelists bring broad experience and perspective. We have a seasoned ambassador, a seasoned judge, and a seasoned scholar and practitioner of mediation and arbitration. I'll give very quick introductions because you have them in your book. Ambassador Chowdhury, to my right, as mentioned, is the former foreign minister of Bangladesh and now graces us with his presence in Singapore as principal research fellow of the NUS Institute of South Asian Studies. He has a long diplomatic career, including posts as ambassador and perm rep to the UN in Geneva and New York, with particular experience on disarmament, which is very important and is relevant for this group, though, today on WTO trade matters. Many publications on economics, WTO, global politics, Pakistan, and Bangladesh. To my left is the Honorable Dr. Eme Karimunda. As you've heard, he's the president of the Rwanda Court of Appeal and vice president of the Rwanda High Judicial Council. The judge has served as a judge on the Supreme Court, the dean of the Faculty of Law, and an advisor to the Minister of Health in Rwanda. So very broad experience. And he's published in the fields not only of criminal law and human rights law, but on the Rwandan Gacaca post-genocide justice process, which we may hear more about today. And then to my far left is Professor Thomas Stepanovic, who is has a chair on the Faculty of Law at Pepperdine University in Malibu, and is head of the Strauss Institute for Dispute Resolution. As I heard Anna Jubin-Brett say this morning, this is the place in the United States for mediation, both training and scholarship. And Professor Stepanowicz himself is one of the most experienced commercial mediators in the United States. He's on the very elite panel of JAMS, has authored, I think, more than 50 books, and also is a historian. And if I'm correct, you are a President Lincoln historian you have the biggest collection of biographies of Abraham Lincoln. Is that what I remember? So
I have a large library.
We may not find our way into Abraham Lincoln today, but you never know. So let me tell you our plan for this panel. I'm going to pose one general and then some specific questions to the panelists to elicit their experience and perspectives on the use of mediation and their predictions for the impact of the Singapore Convention on bridging divides in different areas tomorrow. We definitely have not rehearsed. We've recently met each other, so this will be like a mediation. We have to see where we go, and I will try to be like a mediator in giving some gentle guidance, and we will be saving time for your questions and comments at the end. So here's my big picture question to my panelists. I've authorized about 5 minutes each to address this question. What value does mediation bring to the other international dispute settlement methods we have, namely litigation, arbitration, and of course negotiation? And what might be the impact of the Singapore Convention on the value and use of mediation writ large, not with any particular focus on a region or a topic, but writ large? And I'll start with this impossible task of about 5 minutes of observations with Ambassador Chowdhury, please.
Thank you, Lucy. As you would have heard in my previous avatar, I was a diplomat, and we had learned those days in diplomacy that speech was given to man to conceal his thoughts. But since then, the years in the academia have eroded that particular predilection on my part, I hope. I hope so. I should be as frank as possible in speaking to the question posed. I should be remiss, though, were I to begin without mentioning of the high plaudits that's owed to Singapore for bringing this convention to fruition, and it bears Singapore's name, which means that Singapore is has indelibly marked her imprint on the international legal cartograph. Since the dawn of history, the capacity to mete out justice along with collection of revenue and maintenance of public order have been the major tools of state power. Over time, however, litigation proved expensive and arduous, and hence the quest for other forms of dispute settlement. Enter arbitration and mediation. Usually, arbitration entailed binding process, whereas mediation was non-binding. Arbitration could be conducted by multiple agents, and mediation by a single entity. Arbitration tended to judge a case, while mediation facilitated dialogue with a view to the dispute resolution. Over time, given Asia's culture and ethos, mediation began to gain salience. Reasons, to my mind, fourfold. One, it was less costly. Two, it was seen as more confidential. Three, the parties could communicate privately, as Asians like to do. And finally, the case overloads in other judicial fora, judiciary, were so heavy that resolutions needed a much longer time frame. Now, I'll mention some specific examples where Asian situations or Asian states inserted mediation into their legal processes. China in 2012 amendment to Civil Procedure Code adopted the principle of mediation first in its Article 122, I think. Singapore Mediation Act of 2017, as we are all aware, is purported to provide certainty to this method. in South Asia, the Indian Arbitration Conciliation Act of 1996, it encouraged arbitration and mediation to apply to the process simultaneously, which takes care of some of the questions raised earlier in the earlier sessions, whether it should be one or the other. This could be simultaneously done in the Indian legislation. And in Bangladesh, 2003, the Civil Code, which dates back to the 19th century, was amended to introduce mediation as a part of general civil procedure. However, in Asia, international commercial mediation trailed behind. Arbitration was the preferred option, mainly because of the factor of enforceability. Now, this is where mediation, the convention, becomes relevant. It is because its purpose is to buttress this enforceability. In this regard, as you have heard, that it can be likened to the New York Convention of 1958, which focused on arbitration, enforcement of arbitration awards, and to the earlier Hague Convention as well. Now, to bring some uniformity to the prevalent diversity in approaches to disputes settlement legislation on Citral, and as you have heard, I have been involved with New York, working group devised the model law simultaneously with the convention, and the end product is what we have today. Now, this, as you have heard, is a compromise, a very good suasion for many of us who have not yet signed on to the convention, Bangladesh, for example. We hope that our firms, our governments are persuaded that trade flows will be made easier because of the convention, and because this will facilitate high-value, complex, cross-frontier commercial dispute settlements. Importantly, my last point, it comes at a point in time where the dispute settlement mechanisms of the World Trading Organization, WTO, are weakening. Of course, as Heraclitus has said, that we never step into the same river twice, but we hope that as of today, we are stepping into a river which will flow swifter and better than it had yesterday. Thank you.
Thank you, Ambassador. Judge.
Yeah, thank you. And I'm first of all very thankful for the invitation. And to address the question, I think there are some problems that are shared by all the judiciaries all over the world. Judicial officers are very few compared to the case backlog. Second, the parties are very often dissatisfied. Case logs have increased, and this applies to the process of adjudication and the litigation, whether you are speaking about the court system or arbitration. And if, as a humanity, we are thinking to achieve the same prosperity, to go the same way, to help each other, to strive for the same goal, the only way to achieve it today is to adopt mediation as a complementary alternative dispute resolutions to existing mechanism. Otherwise, judges in every country are tirelessly working, but they're not achieving a lot. They're not satisfying the people they are serving. So the only way we can satisfy the people we are serving as judges is to adopt a mechanism that would help them to own the process and to strive for the same goal. Thank you.
Thank you. Prof. Stepanovic, after a career, what can you tell us?
Let me just say, first of all, how appreciative I am, thrilled really to be a part of this signal event. And I thank the Ministry of Law of Singapore for bringing us all together. You know, my joy in being a part of this is dramatically enhanced by the fact that in this audience today are many of my students from all over the world. And reminds me that at the end of the day, it is all about relationships. We can only be human together, as Desmond Tutu has said. It's the African principle of Ubuntu. That really is part of the core of mediation. You know, I had experience initially as a litigator in the American system. And I had an experience that very few young lawyers get, and that is that I won in every way on behalf of a major commercial client. I won a complex commercial dispute 100%. We got everything that the justice system could possibly give us. All of the compensatory damages my client sought, all of our attorney's fees, and significant punitive damages, something that you don't have to worry about if you're not in the U.S. system, but nevertheless a civil penalty that was significant. All of it was part of the award. We were expecting that our client would be elated, and indeed our client was pleased at the result. But he turned to us and said, you know, we can do better. We need a better system, because look at how long it took us to get this result. 4 years. Look at all of the time we spent, our control group, our officers, key performers in our company, with lawyers, preparing for and presenting in hearings, motion practice, depositions. Said, this is not right. There have to be better, more straightforward, more satisfactory ways to resolve disputes. This was at the inception of what we've come to call the quiet revolution in dispute resolution. You've heard references today to the modern era of mediation. We know that mediation is as old as civilization, but we have, over the last 4 decades, looked at it in new ways. Why is mediation the epicenter, the heart of the quiet revolution? Many reasons. First of all, the potential to save significant cost and cycle time in dispute resolution. And that is always somewhere on the agenda, the list of priorities, particularly that businesses bring to the table. Second, there is the opportunity to bring parties back into the picture, to say, yes, the lawyers are there, but parties have the challenging opportunity to become part of the solution and to help structure their solution. And along the way, perhaps, to maintain, restore, or improve a relationship. These are all really significant things. Mediators not only can be essential to this process in terms of facilitating discussion about the underlying problems, but also tailoring process solutions. And mediators can even be embedded in relationships. There's no need to wait, as we heard earlier today, for something to ripen into a legal dispute. They can actually tackle issues in the course of a construction project or a relationship between a software consultant and a company. There are all kinds of opportunities for mediation. It comes down to control by parties over their own process and their own outcomes, whatever they may be, the ability to tailor flexible solutions. Now, let me just say briefly that this is what I observed as a matter of the American experience. This was just one of the many flowers that bloomed in the last 40 years. For many different reasons and to serve different priorities, mediation has sprung up in many different fields, many different countries around the world. We have much to share. We also have a lot of diversity. What does this platform that we're here to talk about today, the Singapore Convention, provide for us? It provides a signal, unique opportunity, not only for enforcement internationally of mediation, but it really creates a platform for discussion, for further multilateral collaboration on procedures, on some codes perhaps, whether it's a code of conduct or, as we heard yesterday, a code of mediator disclosure, soft law, like the rules of evidence in the arbitration arena. These are all opportunities. So we are not at the end of this process, nor are we at the beginning. We're not at the beginning of the end, but I would suggest to you that today we're at the end of the beginning, and we have a lot to look forward to.
Have to think about that. Thank you. Judge Karamunda, do you think that, again, we're still talking about mediation writ large, do you think that the convention will give it a boost in the eyes of judges?
Yes.
Assuming it will be ratified, which I think we all should.
Yes, definitely. Because what is missing now, it is the mechanism. The mechanism was missing. We can see already from what happened this morning, we can see that the willing is there, the commitment is there. But in many countries, and that is particularly for Africa, and for my own country, we're missing the mechanism and the institutions. So I think the convention will help countries to enforce the willing they had already. So I have no doubt that it will be a way of the future. Yeah.
And my personal view, as I've expressed to many people, including teaching in my own class, is that the convention, if nothing else, and I think it will be much more, gives this halo to mediation, international mediation, that the halo of the New York Convention, the halo of legitimacy, you know, the growing up of mediation in the international view. And of course, we have to see how that plays out, but I think that's critically important. Now I want to move to, as I said, to some more specific questions and ask you all, based on your different experiences in different fields, how you see different actors in different regions or places viewing and using mediation primarily for international commercial and trade disputes, and whether you give a good report card for the future with or without the convention in terms of expansion. And I want to start, I'll go back to Prof. Stepanovic, because a lot of people here are most interested in the convention focus on international commercial or trade economic disputes, in which you have a lot of experience as mediator and scholar. But in particular, how about multinational companies at one end, big multinational companies, and small and medium enterprises? What's your read on their use of mediation in the future? Or maybe now and in the future?
I have to say that multinational companies have, I think, by and large, gotten the message about mediation. Certainly within individual legal systems like the United States, the UK, and various other countries throughout the world, they know that mediation is a significant part of the legal landscape, and that they're going to be mediating at some point or submitting to some kind of out-of-court process during the course of resolution. They really conceive of litigation as litigation, with an adjudicative process as a backdrop for a negotiated resolution, which creates opportunities for mediation. I would suggest to you the same thing is becoming increasingly true of commercial arbitration, that it's arbitration, and that there are, in my experience, repeated opportunities during the course of the arbitration process for a mediated resolution and interplay with mediation of different kinds. For smaller companies, I would suggest that it's a closer question. They may or may not have the kind of legal expertise and experience that has been developed in major companies. Nevertheless, the opportunities are there. I think this is where court systems come into play, and the willingness of a court to serve as a backstop for and backup for mediation. And I do believe that in many cases, the financial, the economic prerogatives are so significant that they're going to turn in that direction, although the numbers are not as significant as they would be for the big corporations. But I think for a long time, there's been kind of a bandwagon effect. the organization that I previously ran, the International Institute for Conflict Prevention and Resolution, CPR, has worked for 30 years since the early days of the Quiet Revolution with major corporations and developed a CPR pledge which said, before we go to litigation or to arbitration, before we get on that train, we're going to seek out informal methods of negotiated resolution.
While we're talking about the smaller end of the spectrum, the small and medium-sized enterprises, again, we're still in the international area. The prior panel talked a bit about AI, and you raised, after lunch in our discussion, the idea of online dispute resolution. Do you see that as particularly promising for the smaller people?
Well, certainly I think that we're just now seeing the tip of a huge iceberg in the form of online dispute resolution. And the convention contemplates online procedures, online agreements, et cetera, whole online systems. We're already living with this in many different ways, fragments of this picture. If you're in mediation or in arbitration today, we're relying heavily on electronic media. Much of the communication is online. Yes, we have set-piece hearings set out in the middle of that, but increasingly, we're hedged about by all of this stuff. I will tell you that right now in the United States, there are quite a number of pilot programs in courts around the country, and it's not just in the U.S., but we've heard about other countries as well, may have been mentioned earlier today. And that is small claims, various low-volume mass cases may be resolved much more effectively and actually create much greater access to justice for people of limited means or organizations of limited means. So this is a way of overcoming boundaries or barriers of time and cost. And I think we're going to be seeing more and more of that. I think I'll stop right there.
Okay. Judge Karamanda, sticking with talking about what one knows, can you give us the African perspective and experience?
Yes, I think the logic is simple for Africa. Africa we're still struggling to rise from poverty, and the latest report from African Development Bank indicates that we are doing well, quite well, 4.1 GDP by next year. But when all perspectives are put together, we found that they are still low. We have to double the GDP. And if to double the GDP, there are advices which are given. We should industrialize our countries. We should increase employment. And yet, we don't have skilled people. We don't have resources. We don't have. So this, the outcome of it will be that Africa will continue exporting its raw materials for another decade, and importing commodities and the services for construction. And when it is in this kind of trade, we're using the traditional mechanism, litigation and adjudication. Africa is the weakest part. So mediation brings Africa to the same table of bargaining. It gives power to Africa for bargaining with equal interest. And we think that considering the spirit of the convention, which is already fitting with the value of Ubuntu that he said, the value of Ubuntu that is shared throughout Africa from south to north, from east to west, we think that Africa, if it embraces quickly the convention of mediation, it will ease and it will benefit further in its trade with the world. These days, the report from the USAID last year indicates that the bilateral trade through the African Growth Opportunity Act for US has decreased by nearly $60 billion.
60
$60
billion
billion by last year. So it means that we need to look at other opportunities, other markets where we can and diversify, you know, the resources, the contact, and these kind of things. The problem we have most of the time is that when we are in this kind of a business and there is a dispute, we have to go to London. We have to go to New York. We have to hire an American. We have to hire a Canadian for dispute resolution. And they apply case laws we don't know, we don't master, we don't know the origin. They don't care much about the interest when we started. Our business people, mostly in Africa, are not really as illiterate as in other spaces. So I think I think Africa is the most beneficial of the mediation process. That's what I think.
Well, Gabrielle Kaufman-Kohler and I, who are leaders in the International Council for Commercial Arbitration, where there's a lot of focus on the training and developing and increasing the number of African arbitrators and training judges to be familiar with the arbitration process. I assume that could be even more dramatic for mediation if there's going to be something of a leapfrog over the next couple of decades with the increased investment in Africa to try to accelerate the development of expertise for dispute resolution. Do you see many efforts in Rwanda or in your region for training, genuine training of local mediators?
Well, as far as alternative dispute resolutions are concerned, globally speaking, we are still setting up mechanisms, Africa globally speaking, even arbitration itself. I remember in my country it started in 2009 only. When you go in other countries like Uganda and others, they are still in the process of building already arbitration. I think this fits the question that was raised by someone from Pakistan. And but the way we are looking at mediation, we are not looking at mediation as a competitive mechanism to existing mechanism. We are looking at it as a complementary approach, something which will come to complement existing mechanism, and which, if it does not work, you can still rely on other mechanisms that are already in place and that for which we have expertise. For the last decade, we have seen tremendous efforts in African countries, starting by Nigeria, Ghana, Kenya, Zambia, Uganda, Rwanda, training the judges in mediation, creating small organs for mediation. In fact, in Kenya, they have created something they call the Mediation Accreditation Committee in the judiciary. In Zambia, they have so far trained 190 mediators in Zambia. So in Rwanda, last week, we adopted a national policy for mediation. In Uganda, there is a law already in place, which they used to have a law that incorporated the traditional mediation, but now they are also including modern mediation, something we can call modern mediation. So I think there is an effort in Africa to rely on mediation. This kind of mediation we are using back home are not yet really for international trade.
Right.
Yeah, but we are mediating first for domestic cases. But I think this is the way to go, to understand the functioning of the mechanism, and in the next future, we can extend it to international trade. I think that's the future.
In Tom's words, this is the beginning of a beginning to move to international. Thank you. Now let's move from Africa to South Asia and get your perspectives on...
Okay, I think But let me tell you, for starters, that in the negotiations in New York, state parties were very circumspect. Hence, we have this Article 8, the option for opting out. In South Asia, you see, a state system, as we know in the rest of the world, I'm certainly in Europe and etc. State system in South Asia is still emerging. It's a work in progress. I mean, there is some kind of an intellectual and theoretical confusion as to whether we should stress the commonalities with our neighbors or the distinctiveness. I mean, whether India, Pakistan, Bangladesh have things in common. If there are too many commonalities, it sort of erodes the argument for separate sovereignty. If there is distinctiveness, of course, it justifies it, but it also makes for conflicts, and of which there are legion. Now, to exacerbate the situation, the post-colonial emergence of South Asia, there were many unresolved disputes left over, including resource sharing, particularly water, for instance. I mean, in fact, it's forgotten now, and it never found a mention today. A very important case of mediation was the 1960 Indus Water Distribution Agreement between India and Pakistan, which still holds good today, brokered by the World Bank. Then again, this is also forgotten, the 1965 war between India and Pakistan formally came to an end with a mediation effort of Premier Kosygin of the then Soviet Union in Tashkent in January 66. There's so many other issues today in South Asia. We have these refugee problems of Rohingya and all that. So the question is these new platforms that we are creating, which would be impartial, which would have the knowledge, the wherewithal, could they address some of these issues as well? I know that we have to be tethered to the convention, but I'm looking at tomorrow. Is it possible for these platforms to develop the wherewithal to, in an impartial way, look at some of these disputes and proffer ideas which could help resolutions?
I think that falls very well with what was said earlier in the panel, that just to have the meetings and the conferences and the discussions at the UN and elsewhere about the convention, even though it's focused on enforceability of mediation, gets these issues back in people's minds and, as I say, on the front burner, and thinking, well, why can't we use it with this and why can't we use it with that at the state level? So it's not the intention of the convention, but I think that's going to be one of the results. It's on the table.
Unintended consequence.
Sure, it's unintended. Now, I'm going to put our audience on notice that very shortly we'll be asking you for your interventions and questions. So while you think about them and build up your courage to be the first person, I'm going to pose one more question, which is on the minds of many of us in the international commercial area, and I'll start with Tom, which is mediation of investor-state. By definition, they're commercial trade disputes, and if the states opt out with Article 8 from having mediated settlement agreements enforced, which wouldn't surprise me, that may or may not have an effect on the current situation and the prospects of investor-state mediation. Can you give us a weather forecast or description or both?
Well, there are a lot of forks in the road. One possibility is, as you said, they may make a reservation to say the state will not be party to mediation under the convention.
No, to enforcement of an agreement.
Or the enforcement of,
they'll still mediate, I think.
Yeah. Let's assume that the state may be subject of enforcement under this convention. Then the question becomes, what kind of mechanism might they submit themselves to? And this area is fraught with concerns related to corruption, or at least perceptions of potential corruption, concerns about transparency, etc. One might posit a mediation procedure that would involve perhaps a whole variety of stakeholders that need to be brought to the table for effective relief. Often, confidentiality is perceived as a a positive element of mediated negotiation. In this particular area, however, confidentiality may be highly problematic because the need is constantly on the part of the state to say, this is all above board, no one is profiting personally from this arrangement. There's no corrupt practice. And so from beginning to end, a process has to be carefully tailored to take all of that into account, and also, I think, to address these issues of peripheral stakeholders. One further thing along those lines has to do with the choice of the mediator or mediators. And maybe there are different kinds of neutral, frankly, that are involved. There might be someone who is playing a more facilitative role alongside someone who's doing something much more directive. But one way or another, often, there may be a need for a stamp of approval, either directly or indirectly by an authority figure who is providing cover, in essence, for the state decision makers who ultimately have to put themselves forward. And this may take a variety of forms, but clearly one aspect of it may be someone who is a very senior judge or former government official, someone who is cloaked with personal or institutional authority or both. So those are some of the major concerns and barriers that need to be overcome if we are to make significant inroads in investor-state issues.
It's a topic a number of us think a lot about, and I'm looking at my former colleague and good friend Steve Mathias. States just face a lot of obstacles in voluntarily agreeing to certain types of settlement with investors, private and public international law in one plane, but that could be, well, it is a whole course for me, so we'll stop there. One last question, though. I would regret if I didn't ask you, Judge Karamunda, to give a very brief description for this audience who may not be familiar with gacaca, and whether there's anything, describe it briefly, whether there's anything mediation has to learn from that, or are they entirely separate?
Okay, thank you. Gacaca is, for those who are hearing it for the first time, gacaca, the word gacaca itself means the grass, meaning
like green grass?
Yes,
just
green
Okay.
grass. Yes, green grass. That's a place where elder people sit mostly in the afternoon to resolve conflicts between people in the community. So, and if they don't succeed, they would appeal to another level, which we call the abunzi. So it's another committee, a family committee, which is a bit higher. So in 1994, as you might know, we lost more than 1 million of Rwandans due to genocide, which was committed against the Tutsi. And the only way we had to resolve the problem was to rely on conventional justice. And I remember at that time I was a student in law school, and there were many NGOs coming in the country and hiring advocates for the suspect. So we had many advocates from Brussels, from Mali, from well-trained advocates in criminal law and international law. And the judges, most of them had been killed, others were refugees abroad, and the system couldn't work. So we spent, from 1996 to 2000, we spent like 4 years trying to use the conventional justice system. Then by 2000, we had more than 125,000 inmates for a space built for 20,000 inmates.
125,000?
125,000 inmates for a space of 20,000 inmates. So the estimates were saying that if we continue using the conventional justice, we would spend 200 years trying these cases. If we would send these people to International Criminal Tribunal for Rwanda, it would take nearly 250 years, because the ICTR was slower than ordinary courts. So, and there were claims from victims and claims from the suspect. NGOs saying that it was the abuse of due process and the human rights, things like that. So, the only alternative we remained with was to rely on our traditional mechanism, that's the gacaca, as a restorative justice, because we're looking primarily for 3 goals. The first goal, to deliver justice to all culprits without giving amnesty. The second goal, to reconcile the people, to create a forum where the victim and the suspect can meet and can exchange. Because in conventional justice, we don't have this. In conventional justice, you have judges who are in black robes and the advocates speaking Latin and French, and so you don't have forum for linking the suspect and the victim. The third goal, and through the process of reconciliation, was to find out what happened, why genocide, where are the remains of our beloved ones. So how can we, overcome this situation? So that's how we started Gacaca. We trained layman people in basic norms of criminal procedures. They were not entitled to have lawyers, so it was done by lay people. And from 2000 to 2010, there were 2 million cases which were solved.
2 million.
2 million cases. So if today we can speak about Rwanda, if Rwanda exists today, it is partly due to the job done by Gacaca. Because now we are speaking as one Rwandan. We don't look at each other through the tribal lens or Francophone, Anglophone, or whatever. So we speak as one Rwandans. We are looking at the same goal, and the Gacaca has played the role of restorative justice. These lay people, they were like the repository of something. There is a professor from Harvard University, William Ury, who studied the Bushmen of the Kalahari Desert in Namibia. And he found out that there was a traditional mechanism where two communities, when they're in conflict, they would have a third community. That will be a repository of the conflict in that third community. So they will interchange the role within that community. So that's what we did for Rwanda. So these lay people, they absorbed all the sorrows of the victims, all the narrative of the suspect, and we could move on. So we have remained with a few cases on genocide. People were fugitive here and there, which are now brought before conventional justice through modern mechanism. But Gacaca has helped us to rebuild the social tissue that was already broken. And from Gacaca, now we have the spirit of Gacaca. We took the legacy of Gacaca, we created another institution we call the Abunzi. Abunzi in Kinyarwanda means mediators. So the Abunzi are the people who are in the community mediating for problems before they can reach the court. So the problems they cannot mediate, those problems can go to the court. But all those which can be mediated, they can remain there and the issue is solved. Okay.
So we've moved beyond mediation of international commercial disputes, but the spirit is there in the mediation ethos.
Yes, indeed.
It's something for us to learn from.
Back home, we think that mediation, it is an instrument that cannot be limited to commercial disputes only. It is possible to extend mediation to other fields where there are conflicts, including a land dispute, a succession dispute, a family dispute, divorce, including some criminal matters. Yes.
This panel is building bridges to tomorrow, so there you go. Now, do you have 30 seconds of comment.
30 seconds.
And
Just
we'll
one
start with questions.
point with regard to indigenous methods of addressing issues. I mean, we also have what we call salishas, village sort of gatherings where disputes are mediated. Or in the northwest, I spent some time in the frontier province of what is today's Pakistan. In Afghanistan, Pakistan, you have jirgas and all that. One problem with those is the due process of law. I mean, that's very important. If there is miscarriage of justice, that has to be avoided, and the how evidence given is weighed. Judge and I were talking about the Evidence Act in a situation. I mean, one of the things we were taught as magistrates was this is the most important element of meting out justice, how you weigh evidence provided. And the fear is that in these circumstances, as we have in Africa and our countries, in villages and all that, proper weightage, a determination of weightage to be given to evidence is never done perfectly. Nothing is perfect, of course, but the traditional courts of law are an improvement on these. So that is the usual norm and usual received wisdom in our society. Thank you.
Thank you. Questions and comments from the audience? Succinct ones, please. I was trained at the Council on Foreign Relations, so please don't make me cut you off. Yes. Microphones? Thank you.
Okay, I'm from Singapore. I'm a commercial mediators and a community mediators. My practice is mainly in Singapore. So we are talking about mediating, we are talking about manning wall, building bridges, to bridge the differences of people. In Singapore, we are living in mainly housing boards. So we have multinational, multiracial, multi-religion, and sometimes we are multicultural. So to bridge that in a community way, but now with today, all right, the Singapore Convention on Mediation has been signed. So when we're talking about international commercial dispute, can we hear from you, share with us your experience? How do you actually overcome and bridge the differences of different nationality, culture, or even behavioral norms of different nationality? Because that is something that we are very domestic in Singapore for the last 20 over years. We'd like to hear your experience. Thank you.
Let's take 2 or 3 questions. And I think that question, Tom, you would best answer. A couple more. Yes, please, sir.
Delroy Chok from Jamaica. Question of costs. For instance, judge in Rwanda, who paid the mediators who assisted in settling those disputes? Again, in Jamaica, we're trying to promote mediation, but then the litigants will say, but the state should pay for the litigation. Now, in a country of limited resources, it's very difficult for the state to pay all the mediators for cases that come to the courts. And again, even cross-border mediation, you may have a very powerful, dominant company in one state dealing with a weak a weak partner or contractor in a country. Who decides the payment of the mediators? And isn't it an imbalance where the powerful company can pay more as against the weaker partner who may not be able to afford the costs? To what extent should the state be responsible for promoting or paying these mediators?
Thank you. One more question on the... There you go, sir.
Armstrong from Dentons, Shanghai. New York Convention create an industry, arbitration industry. But today we could see this industry sometimes harms the commercial industry. As I know, in London, the arbitration industry brings more GDP than the insurance industry. So my question is, how to stop Singapore Convention from create a new world that harms the commercial sector, how to reduce the cost, how to raise the efficiency of mediation. Thank you.
The question is how to stop the Singapore Convention from creating a new wall? I didn't hear you.
How to raise the efficiency, how to lower the cost.
Okay, thank you. All right, we'll start with 3. Tom, do you want to address the attributes of a good cross-cultural mediator?
I think
Or
the first
any
question
question.
actually had to do with harmonization of different systems arising from different legal systems and cultures. And this is significant. This is part of what we'll call it an opportunity that the convention gives us. And this is something that we've dealt with in the arbitration arena as well. Let me just speak briefly about this. What is mediation? What are the roles of mediators? We do not have perfect agreement on those basic questions. In some countries, mediators can do whatever is necessary. Facilitate, evaluate, elicit, direct, etc. Whatever it takes. In other countries, they are denied the ability to evaluate. That's not mediation. Someone else does that. That's conciliation. Maybe arbitrators do that. Maybe courts do that. Notice that the very way we conceive of these roles often is a child of our culture, of our long historical background, of our legal system. And let me suggest it's also affected by the gravitational pull of the legal profession. For example, in Los Angeles, where I live, we discovered through a survey of the International Academy of Mediators that arbitrators in Southern California are particularly likely not to use joint sessions. Why is that? Largely the impact of the legal profession and the preferences of local lawyers. So there are a lot of factors here. We're talking about trying, under this convention, to address international standards. And I think it's a very healthy thing to be saying, okay, we know what we think mediation is. What does someone else think? I've done a lot of work in China, working with various partners. And we understand that, China has ancient roots, mediation, different concepts of where mediation comes from, what it's intended to do, who the mediators are. Typically now, they are figures of authority. Often they are arbitrators or courts or government officials. But that's in the process of changing. And part of it is a result of international dialogue. Likewise, in the U.S., we're thinking in different ways about stuff we take for granted. In the arbitration area, we had, just to give one example, of a very effective standard of what we call soft law, and that is the rules of evidence for use in international commercial arbitration, as opposed to arbitration within a country. And there was a successful, increasingly successful harmonization of what I'll roughly call common law approaches and civil law approaches in that standard. That's one of the widely used standards that's had a dramatic impact. I think we're going to need to have these kinds of dialogue in the mediation arena too. That will be very healthy. But we also have to recognize that mediation is inherently flexible, and that's one of the things we like about it. So how do we preserve that? One thing to think about is maybe we recognize over here we have a preserve for international commercial disputes. That's a different animal from domestic mediation. Even though you may have commercial parties that work in both areas and need both systems. But we have this in the arbitration arena. We have different rules often for international cases than we do domestic. No reason why that couldn't evolve. But I think one thing we want to keep in mind is we don't want to kill this butterfly with the weight of regulation. We need to be clever we need to be creative about the way we do this. I hope that is in some ways responsive.
Thank you. We have two very different cost questions. The first one, question on cost of restorative justice and mediation. But Aimee, would you address the ambassador's question on costs in restorative justice when the state brings in a sort of a massive process?
I think I agree with the professor that the Convention on Mediation has set up an international legal framework, but the implementation will depend on country policies. Now, as I said, we are at the starting point in many African countries. The mediators in Kenya who have been appointed, they're paid through the budget of the judiciary.
The judiciary's budget.
The judiciary.
The state through
Yeah,
the judiciary.
The judiciary's budget, meaning the state. I haven't found out how mediators are paid in Zambia, because there are 190 mediators, I said, in Zambia. But for the restorative justice we relied on in the criminal matters, it was sponsored by the government. It was sponsored by the government. But in my court, in the Court of Appeal of Rwanda, where I sat a few months ago on a case on mediation, the parties bear the cost of everything. So I think we cannot say that this is the way to go now. It will depend definitely on different circumstances, different approaches that every country can adopt. What matters is to agree on the fundamental principles and the way to go. The implementation, I think, might vary.
Iftikhar.
Well, costs, yes. Unfortunately, that's a real problem. I know of situations, for example, in the WTO, when the WTO dispute settlement body, it's more arbitration than mediation, really. But you see, the wealthier party is always at an advantage, If the Caribbeans want to take the banana issue to vis-a-vis the United States to the WTO, guess whose advantages? Or we want to take an issue of Bangladesh garment exports to Canada or something like that, or European Union. Surely, I mean, they have far greater wherewithal even to use the systems within the international mechanisms like the WTO. Yes, but one of the things we learn in international relations, sadly, is that just because there is a problem does not mean there is a solution. This is one of the problems that we genuinely need to address.
As for the question on costs in the convention and costs, with or without the convention, really the responsibility for controlling costs in mediation rests on a firm mediator and an institution well, I am an international lawyer, to keep them from taking over and allowing it to cost
cost of the lawyers
too much. Well, but the cost of the lawyers is always more than the cost of the mediator, so the mediator should be setting guidelines. And we could talk more about that question, but we have 3 minutes, so we have time for one last quick question or comment, please. Someone in the front row here? The third row. Sorry, sir. We can do them offline after.
As a judge, should remember the lady behind.
Sorry?
There's a lady back there.
Oh, there's a lady in the back too. So 2 quick questions.
Samir Sattar from Bangladesh, Supreme Court. Just touching on the butterfly point, do you think that the convention, by giving the parties an opportunity to challenge the settlement agreement, is in effect, in a way, diluting the rise of mediation? Do you think that the fate of mediation will eventually be the same as the enforcement of arbitral awards, as we see in Southeast Asia? Thank you.
can answer that quickly. I think not, because even now, if two parties have entered a settlement agreement and one wants to walk away from it or has buyer's remorse and they're not going to comply, they're going to be in court, and that will be reviewed for questions like fraud or lack of capacity. Or so I'm hopeful. I know some people say the convention will add formality and slow things down, but I'm hopeful that's not the case, and I think the profession has a responsibility to try to keep that from happening. There's a lady in the back, you said. Yes, please.
I'm not sure if this is, oh yeah. Hi, my name is Ramya. I'm from India, and I'm a 21-year-old lawyer and a trained mediator. So I feel like with the rise of ADR and mediation in specific, we have a lot of court-annexed and private mediation centers which complement the courts, and privatization of justice dispensation is good when it eases the burden of the courts. But if we're being futuristic and if we try and prevent problems from happening, do you think that privatization of justice dispensation, if left unchecked and unregulated, could create problems with respect to transparency? So let's say the rise of mediation centers without a proper framework in a certain country, whereas some countries might have a framework, but it's hard to do that and hard to bridge differences in regulatory issues within countries, because obviously you don't want to kill a butterfly with a heavy regulatory mechanism. But how do we come up with these creative solutions, or do you have any way of trying to mitigate the risks of privatization which go unchecked?
Did you? I didn't catch it. Sorry.
The question is whether, comes up in arbitration as well, whether the privatization of justice outside the court system through mediation deprives the public of precedents and equal access, for example, which is I've written about this in arbitration, but do you think, I'll pose it to Tom, that mediation, which isn't going to be driven by necessarily legal norms or legal precedents, is the privatization of justice through mediation is a problem?
Well, you know, we've wrestled a lot with these kinds of issues as a policy matter in the United States. My own view is that there has always been a significant amount of negotiated resolution. Mediation is simply addressing a need that was previously unmet. There will still be cases in the system and adjudication on some level of most kinds of cases. There are exceptions, but I think, let me answer one more quick thing. I know we're out of time, but let me just say, okay, rule of law, very, very critical. This stuff that we're talking about here is not a wholesale substitute for a court system and independent and impartial judges. I thank God that, I live in a country where there is at least conventional commitment to impartiality and independence of the judiciary.
And the last word, as always, to the judge.
Okay. Thank you. For the issue of privatization of justice, I think for the commercial arbitration, commercial mediation, it is started from an agreement, a breach of agreement, or a disagreement. So if the parties can agree where they were disagreeing, so for the justice system, there's no problem at all. So that should be the way to go. Back home, we are even thinking that, as far as the commercial cases are concerned, that we should be more and more consistent in rulings so that advocates and lawyers can know beforehand, so the predictability, the rule which will be applied to the case, so that it can force them to go to mediation. So we don't see that as a privatization of justice. There is no link at all. It is an alternative which is given to people who would have wished to have a means to control the system. So the parties, when they enter a case, most of the time you find that they even don't know the legal terms which are applied. They can't even understand the ruling which is delivered by the judge. So if now we gave them an opportunity to solve the problems they had created themselves, I don't see where we can mix it with justice. Thank you.
So to conclude, the rise of mediation, bridging differences for tomorrow, is that it's complementary to the other international dispute resolution mechanisms we have. Would you join me now in thanking our panel?
And applause as well for Professor Reed for moderating the final panel discussion as well. Thank you, Professor Reed. Thank you.